Subscribe to get contents via mail. Purchase shorthand journals and more.
Accordingly, after being discharged from the aforesaid criminal case, he submitted an application on 26/2/2019 to the authority for allowing him to rejoin the service. Unfortunately, authorities have not responded to the same, because of which the petitioner has approached this court. This court is of the view that though a contractual employee has no vested right to continue in service in the present case, the break in service was occasioned due to certain criminal case which was foisted upon him, in which he has been acquitted, and as such the break in service was not due to any deliberate act on the part of the petitioner, but due to reasons beyond his control. If that is so, if similarly situated persons who were appointed on contractual basis have been allowed to continue and the service of the pharmacist is still required, the authorities will consider taking the petitioner back break in service so that he may be allowed to continue in service as pharmacist as was done on the earlier occasions. Learned Counsel for the State respondents submits that since the contractual period of the petitioner has already expired, there is no vested right on the part of the petitioner to seek reinstatement in service. However, as mentioned above, this direction would be compilable only if other contractual pharmacists/employees have been continued in service, as the petitioner also would have continued in service had he not been implicated in the criminal case from which he has now been acquitted. Accordingly, the present petition is disposed of with a direction to the respondent authorities to consider the said representation submitted by the petitioner on 26/2/2019 and pass appropriate orders in terms of the observations and directions mentioned above within a period of 1 month from the date of receipt of a certified copy of this order. As can be seen from the order dated 11/4/2019, this court had held that though a contractual employee had no vested right to continue in service, the break in service of the petitioner was occasioned due to a criminal case, and that the authorities could consider taking back the petitioner in service if similarly situated persons were allowed to continue and the service of the petitioner was still required. In compliance with the order dated 11/4/2019 passed in WP (C number 2509/2017), the respondent number 2 issued the impugned order dated 30/10/2019, which states that the state level committee under the chairmanship of the Executive Director NHM Assam had assessed the pharmaceutical knowledge of the petitioner.